Question is that the motion be agreed to, and I call the honourable member for Wills.
Thank you, Deputy Speaker. I do not support this motion. The environmental law is there to protect the environment and to protect endangered species. The member for Dawson's own party brought it in. All environmental groups ask is that mining companies, agribusiness and so on don't break the law, just as environment groups and ordinary citizens are expected to abide by the law. If companies abide by the law, there is no issue. All the provisions that the member for Dawson complains about do is give people a right to take action if the environment law is not being complied with. The implication in the member for Dawson's motion is that mining and other companies shouldn't have to comply with the environmental law, that they should be able to break it with impunity. The member for Dawson may not care about the black-throated finch, but I do. It is a beautiful little bird. We should not push it to the edge of extinction in our quest for ever-increasing material wealth. Mining booms come and go, but black-throated finches don't. If the black-throated finch becomes extinct, there is no way to bring it back. We have the EPBC precisely because we have learned from the mistakes of the past, and we should support it and strengthen it, not undermine and white-ant it. Since being passed by the Howard government 16 years ago, the Environment Protection and Biodiversity Conservation Act has been the overriding national environmental protection law, including throughout the mining boom, and environment groups are required to operate within this law. Since the Act commenced in the year 2000, there have been approximately 5,500 projects referred to the minister under the Environmental Impact Assessment provisions. Of those projects, around 1,500 have been assessed as requiring formal assessment and approval. Around 33 actions have been commenced in the federal court by third parties in relation to the EPBC Act's Environmental Impact Assessment process. The proceedings taken by third parties have only related to 22 projects that had been referred under the Environmental Impact Assessment process. So this means that third-party appeals to the federal court only affected 0.4% of all projects referred under the legislation. Deputy Speaker, environmental advocacy is in the public interest. Environmental advocacy enhances environmental decision-making, accountability and drives policy reform to protect the environment. The Australia Institute conducted national polling and found that 68% of Australians support environmental advocacy. While 27% said environment groups had too much influence in public debates, 34% said they had not enough influence. By contrast, most people, 62%, said big business and mining companies, 58%, had too much influence. While 6 in 10 Australians are concerned that big business and mining companies have too much influence, the Coalition enthusiastically promotes them and even encourages them to become political activists and fight government policy. In the last 5 years, the mining industry has spent $340 million on lobby groups and more on registered lobbyists and in-house lobbyists. The government is arguing to silence environmental activists, while on the other hand they want industry lobbyists to become activists. The irony, the double standard. Section 487 was designed to address issues of standing, a legal term that broadly means an individual or group's right to challenge an approval on the basis that they are either affected by it or have a special interest in the outcome. It does not provide for open standing, whereby anyone can bring an action for review, but it does authorise representative standing in which groups can act on behalf of an affected community. This is a crucial component of the National Environmental Act, which seeks to promote rigorous and effective environmental review for approvals that potentially affect matters of national environmental significance, such as the development of Queensland's Galilee Basin coal deposits. Removing Section 487 will stop environmental groups from acting on behalf of affected communities and from performing their important function as a watchdog. As the Australia Institute has highlighted, advocacy is essential for a well-functioning democracy, providing for those most affected by government decisions to be involved in policy formation, helping keep government accountable to the wider community and counterbalancing the influence of corporate organisations over government decision-making. Robust environmental review by focused, engaged, representative organisations like the Mackay Conservation Group and like the Australian Conservation Foundation has never been more important. rolling back the legal provisions that allow this to happen would be a backward step.